Good. Welcome back to the People's Law School. Again, the best kept secret in town. We hope everybody's having a big time. I know I'm learning something every time I hear one of these lawyers speak. They say the worst mistake you can ever make is give a lecture to your own peers so that they can learn your tricks. That's a statement I've heard from our next speaker, Mr. George Beason. A lot of you, I'm sure, know George. George is from here, grew up here, has a lot of family here. The Beasons are all over town. He graduated from Huntsville High, the University of Alabama, and then Cumberland School of Law. For several years, he was the chairman of the board of the Alabama Space and Rocket Center, so he got to turn on the lights every year on that big old Christmas tree. George has excelled in all areas of the law. He's speaking tonight on contracts, which is, as he said, how come I got contracts? He's a real good lecturer, and but let me tell you one story about George. He and his brother Tommy, and this is a true story, y'all know Tommy, he's a CPA that works right down the street. Well, George and Tommy Beason are out in a boat on the Tennessee River a few years ago, and a snake, about 20 yards away, a snake came up out of the water and was looking just like this. So George had his gun with him, a .38. Pulled it out and at 20 yards aimed it at that snake just like this, waited a second and went bam and hit that snake right between the eyes. This is a true story. Impressed his little brother Tommy for sure. And for years I've heard all about the story about how George shot the eyes out of this snake. What I didn't know, a friend of mine, Johnny Hall, who's a U.S. Marshal, said, Brinkley, that ain't no big deal. They teach everybody at the FBI Academy, if you ever want to kill a snake, just point your gun at him and he'll line up on you. You can't miss him. So, but when I first heard that story, I thought, wow, that's George Beason. Because he did go to the FBI Academy when he first got out of the law school. Little tidbit. But in any event, George Beason will talk to us on contracts.
Now you know why you don't tell lawyers stories and then sit down and expect not to hear them come back at you. Alan always tells a good story, and he says they're true. I did shoot the snake, but the rest of it I don't know about. It is indeed an honor to be here today, and I think this is just fantastic that we have a group of people that want to get together and study the law a little bit. And you know, it makes you appreciate the fact that we are Americans, that a small band of people could assemble on public property under the cover of night and talk about their rights. And nobody's going to come through that door and arrest us, and nobody's going to hassle us, unless it's Judge Smith who owns this courtroom. But, you know, it's what a fantastic thing. And as we like to say, you can fight City Hall. This is the only way I know you can fight City Hall. You can go down there and ask them for help, but this is the only way I know that you can fight City Hall, is to expect the law to help you, and right now it does. And don't y'all let them take your rights away from you. Study everything that comes out, and don't support any legislation that you don't know exactly what it's all about, because normally every time they pass a bill, it reduces our rights a little bit. All right, I have taken the liberty of making some notes on the board over here. I know you've heard a few talks prior to this. Has anybody explained that the law is set up a criminal side and a civil side? And on the civil side, we have the law section and the equity section. And under the law section, we have torts and we have contracts. Contracts is a huge subject. It's something It's something that will touch all of our lives, and a lot of us on a daily basis. I would say the majority of us, it touches us on a daily basis. It could be that you will not be touched by a tort, and I hope you are not. That is a civil wrong. That's injuries. That's defamation. That's fraud. That's car wrecks, plane crashes where somebody gets hurt. And I hope that doesn't touch you. But on contract side, it'll touch you probably most of us every day. I saw a statistic recently, and I believe this to be correct, that contracts make up 50% of all lawsuits filed. Torts, which is one we hear the most about, make up 5%. The other 45% would be on the equity side. And I don't know the statistics, but probably a great number of those are domestic cases. Divorces, modifications, child custody, those type things. On the equity side, you have, it's called the court of conscience. There aren't any real hard, fast rules except, as far as the law concerns, there are some maxims that you go by, but the court is asked to do what it should do in good conscience, and that gives the court a wide latitude. So 50% of the cases are contract cases, and a contract case is anywhere from buying a house. When you sign a contract, you know that's a contract case, to charging a sweater at Parisians. You got a couple of contracts there. You contracted to buy it and pay for it. You've also have an implied agreement from the manufacturer that's suitable, those type things. So it's something you're going to see every day. The contract cases are tried by both judge and jury, depending on whether or not a jury is requested. The jury, and this is a good-looking jury right here. I'd take this jury right now on any case I've had. O.J. might not want you, I don't know. I haven't heard how O.J.'s done today. But it's tried with both the judge and the jury, and each side has the right to request that a jury try the case. A lot of preparation goes into most of these cases that are tried. Sometimes it's always months, and sometimes it's years of preparation. But the trier of the fact, which is the jury or the judge, in a non-jury case it'd be the judge, the trier of the fact makes the decision as to whether or not one side wins or loses, whether or not an injunction should be entered, whether or not damages should be awarded, those type things. It's the lawyer's jobs to present their client's side of the story. It's not my job, these are George Beason's ideas, it's not my job to get justice. It's my job to win. And I'm not talking about doing anything outside the bounds of what I'm allowed to do under the rules of evidence, but it's my job to win. It's that other lawyer's job to win. It's the jury's job to sort out the facts and to render justice, or the judge, as the case may be. And what is interesting practicing law, what I find is the person who wins got justice. The person that loses did not get justice. I've never known anybody say, well, George, I think he's right, let's just cave in. He doesn't do that. If my client wins, there's justice in America, everything's wonderful, the judge was wonderful, the jury was wonderful, the lawyers did a great job. But if he loses, a lot of times he looks just the opposite on the entire system. So when you hear stories about lawsuits and court cases, and whether it's the black side of it or it's an outrageous side of it, you can ask a lot of questions. You'll find that a lot of times it wasn't quite the way it's presented to you. Contracts are designed to solve problems, not to give problems. The reason you have it in writing is so there'll be no misunderstanding. One thing. Another thing is to make sure what you've contracted for occurs. Before I start, I want to give you a few rules of law that I think would be of interest to you in dealing with contracts. One is that a contract is construed most strongly against the person who drew it up. Now that's talking about ambiguities, words and provisions that are subject to different constructions. the person who drew up the contract, the law will construe it against that person. So if it has two meanings, the court and the law will give it the meaning that's most beneficial to the person who didn't draw it up. And a lot of times in litigation, that is extremely important. Because to tell you the truth, when you start litigating a contract, you're going to find there's a lot of it ambiguous. You didn't think there was. Another rule of law, or it really is not a rule of law, but a rule that I think you should live by as far as contracts are concerned, is when you sign a contract, you assume it is valid and enforceable. Don't ever sign a contract thinking, well, I don't have to live up to that, because you're probably going to find out that you will. Now, there's a chance you might not, but I think it's just a good rule to live by on contracts. Assume that it's valid and enforceable. Something that's kind of interesting on a contract for a house. Any piece of real estate, you enter into a contract for a piece of real estate, and it provides in that contract that the house will be in certain condition, the property will be in certain condition, air conditioner is good, whatever. That contract will not survive the deed. Once the house is conveyed to you, that contract did not survive. The terms of that contract did not survive unless you specifically provide in the contract that the contract will survive the passing of the deed. And that's gotten to be real important. People come in and say, no, they told me they would do this, and they would do this, and they would do this. And there's nowhere in the contract does it say it would survive the passing of the deed. So consequently, we're in kind of bad shape on that. The statute of limitations. Do you understand the statute of limitations? That's the time period within which a lawsuit can be filed. And you will find that during that period of time, you can get everybody's attention if you want to talk about a problem you're having. But the day that thing runs, they quit being nice to you. And we call it the running of the statute of limitations. If you've got 6 years from the date of an injury or a breach to file a lawsuit, and you deal with them for 6 years and 1 day, and you argue with them and so forth, you'll find that they're a lot nicer to you prior to the passing of the 6 years, because you can't do one thing to them. Now, that's a normal contract under seal. This kind of shows Alabama law, and probably not just Alabama law, but at least Alabama law. A contract under seal, statute of limitations is 10 years. You know the difference? One has the word down there by the signature that says parentheses seal, and the other one doesn't. I don't know why it's that. Well, I imagine the king or somebody used to put the ring in the wax. But it's still given a distinction today. You get 4 years longer to sue somebody on a contract if it's under seal. So you'll see that on some contracts, you'll see the word seal. And that's the only significance I know that word has to it. There is a provision in the law known as laches. And laches is that you did not pursue your claim quickly enough, even though it was within the statute of limitations, that somebody would be put to a disadvantage because you have waited 6 years to file a lawsuit. And sometimes that will defeat your claim for a breach of contract. Not very often, but sometimes it will. Parole evidence, another rule of law. Parole evidence will not be admissible when there is a written contract. Now, I'm talking about in court. When there's a written contract, you are not allowed to get up there on the stand and say, well, when I bought this car, I know it says I bought it as is, but the seller told me he would fix the transmission and the engine. The verbal testimony cannot go to change the written portion of the contract. Now, sometimes you can have testimony as to the events that led up to it and those type things, or if you're arguing over the construction of a certain provision, you can have verbal testimony. But the verbal testimony cannot be used to change the meaning of the written agreement. Attorney's fees, that's another thing. I have lots of clients that come in and say they breached this contract, and I want you to sue them for the damages, and I want you to get your fee too. Unless the contract provides for attorney's fees, it is not part of the damages. You cannot collect attorney's fees unless it's specifically provided for in the contract. So if you enter into a contract and you feel that's important, it's got to be in there. I have been accused from time to time of only telling them about cases where I won. And if that occurs tonight, that is because I'm only going to tell you about the cases I won. The good Lord has not allowed me to remember those others, and I appreciate that. If I work real hard, I can, and it doesn't make me feel very good. But I'm going to tonight try to go through contracts, the elements of contracts, and we'll do that kind of quickly. And I'll try to give you some examples of the situation we're talking about. The elements of a contract are found in its definition. A contract is an agreement, first element, between two or more persons, or of course entities, corporations, partnership, persons can enter into a contract. That's the second element. Based on a valuable consideration, that's the third element. To do or to refrain from doing a particular lawful act, and that is the fourth element. Now, in order to have a contract, you've got to have all four of those elements. And when we try a contract case, the first thing we do is prove those different elements. So now we've got the contract proved. Then we go to, did our client perform? Did the other side not perform? Damages and so forth and so on. It's not as easy as we would like for it to be. You start arguing about whether or not there was an agreement. In order for there to be an agreement, there had to be an offer and an acceptance. Was an offer made? Did the other side accept that offer prior to the time the first party withdrew his offer? Because if he withdraws it before it's accepted, it's not a contract. So we deal with that. If a real estate agent comes to your home, you want to sell your home, you enter into a listing agreement with him to sell your home for $50,000. You'll split closing costs, whatever details you have. The agent then goes out and he advertises your home, he or she advertises your home, and a buyer comes in and says, I'll give $50,000 and I will do everything they want to do. Before the offer is withdrawn, then you've got an agreement. But in that case, you've got two agreements. Then you've got an agreement between the seller and the real estate agent. And that agreement says that if he finds a buyer ready, willing, and able to buy this house on the terms being offered, he's entitled to a real estate commission. And I've litigated that, where the seller decided he didn't want to sell for whatever reason. I just don't want to sell. And the agent says, well, I'm entitled to my commission. I've advertised the house and I've done so forth and so on, and I want my commission. And the real estate agent felt like he could not win in the courthouse. The real estate people, and I don't know how many of y'all in the real estate, got real estate people, were led to believe that maybe they couldn't win in the courthouse, and that's not true. We tried that case and won the case, and it is a little bit difficult because the buyer had to have committed to each one of the details. But we got that done. It has to be between two or more competent parties. Now, every party to a contract is presumed to have been competent. A person under the age of majority, which is 19 in the state of Alabama, has the right to void the contract. So you obviously, if you plan on holding anybody to the contract, you need to make sure that they're over 19 years old. People who have been declared non-compos mentis, people whose minds aren't right, they didn't understand, so forth and so on, they present that as a defense. And the burden is on them to prove that they did not understand and they did not have the capacity to contract. Of course, if they've been declared non-compos mentis, in the probate court, that's pretty easy to prove. You come up with a certificate and they're out. We have litigated that issue, not where there's a non-compos mentis, but where a young girl was raped. And her employer gave her some money and she signed a release. And we litigated that release, which was a contract. Whether or not she appreciated what she was doing, whether or not she was capable of entering into that agreement. There's not much about any of these elements that somebody has not litigated over because they've had a problem with that in the construction of it. It has to be based on the mutual assent of the parties, which means a meeting of the minds. You both have to be talking about the same thing. There have been occasions where people have bought the wrong lots. I've seen that. They go out and look at the lots in the subdivision, and they like that lot, and they go back, and that's lot 14, and they buy lot 14 and find out it was really lot 13. And we normally get that straightened out. I handled a case one time where an engineer was hired to build a computer for a restaurant. And the computer was to provide the customer the ability to walk in and look at a menu and punch buttons. I want a steak, I want a number 2 steak, I want it well done, I want French fries, so on. And it totals the price, the charges, and it tells the cook what to cook. And this was a Huntsville engineer, and he told the restaurant man that he could do that. He could build this computer. Now, this is a long time ago before we really knew what computers could do. But the restaurant man said, well, if you can build it, and if it works, I'll pay you $10,000. So the fellow built it, put it in, and he punches the buttons, and it did everything it's supposed to do. Except this restaurant was on the side of town where people aren't as educated and as worldly as other people, and they would walk up to this machine and they refused to use it. It intimidated them. So the restaurant man says it doesn't work. And my man says, yeah, it does, watch. And he said, but my customers won't use it. So we litigated over that. Now, that was kind of a ridiculous thing, and the jury didn't have any trouble whatsoever deciding that there had been a meeting of the mind and it did work, and this restaurant man would pay for it. There are times where that one side or another would claim that there was a mistake, a unilateral mistake. A mistake on the part of one party normally won't get them out. That depends on the situation. The lot and that type thing probably would work. A mutual mistake, both sides have a mistake, that's going to get them out of the contract. Fraud, duress, those type things, undue influence, that'll void the contract. Those are all defenses. It's got to be supported by consideration, and it's got, talking about past Christmas gifts, I gave you some great Christmas gifts last year, and you need to come rake my yard. That's not valuable consideration. It's got to be a legal consideration. Gambling is not a valid contract, although I've always not real amazed. They don't have any trouble collecting those gambling debts. Even though it's not a valid debt. They could come in this court and be relieved of that obligation. They might not live long to tell about it. I represented a young fellow one time who had entered into an agreement with an Iranian to beat up another Iranian. And, of course, I was representing him in the criminal case after he had done that. But that would not have been a valid contract. He could not have enforced, and he was happy to get out of the thing alive. The form by law. All right, we got express contracts, which are written or verbal. Verbal contracts are binding as much as a written contract if you can decide what was agreed to, except under certain circumstances. I'm going to tell you about statute of frauds in just a minute. Statute of frauds says certain contracts have to be in writing. Then we have implied contracts. And implied contracts are such things as warranties, marketability, the product is suitable for the purpose in which it was sold, repairs, the implied warranty is that the repairs would be done properly and they would have to stand behind those for some particular length of time. We also have quasi-contracts. Quasi-contracts are contracts created by the law, such as somebody coming to cut your grass and they made a mistake, but you knew he was out there cutting the grass and you allowed him to continue cutting the grass and you reaped a benefit from that, then that would be held to be a quasi-contract that you really had entered into an agreement to pay him when you allowed him to do the work. There's a cause, a way to be compensated called quantum merit, and that is whatever it's worth. And that in the grass cutting where the man cut it by mistake, there wouldn't be an agreement for a particular value, obviously. So the court would then look at what would the reasonable value of those services be rendered. In the case I was telling you about the restaurant, that's what they did with the computer. I started at some point when the man said there wasn't a contract, I said, okay, fine, we'll say there wasn't a contract because I've got testimony that this computer he was willing to do for $10,000 that all these other people said they'd have charged $15,000. So I want $15,000 since we're going to try this thing. And the jury awarded more than the contract price, but the judge told me we had to reduce it or he's going to make us do it again. So we did reduce it. But we started in the middle of the trial on quantum merit, the reasonable value of the services. All right. That's the end of the elements of a valid contract. I told you certain contracts had to be in writing, otherwise they're valid contracts. And the provision in the law that provides for that's known as the statute of frauds. And it is used as a defensive measure. If somebody files a lawsuit on a contract, as the defense lawyer, you would consider the statute of frauds. You'd look at the contract and see whether or not you felt this agreement had to be in writing pursuant to the statute of frauds. You've got them listed in your handout, but the ones that we're normally most interested in requires that certain kinds of let's see, an agreement which by its terms is not to be performed within 1 year of the making thereof. So an agreement that is to be performed at a period of time that is greater than 1 year has to be in writing. Haul gravel for 2 years or whatever, it's got to be in writing. Every contract for the sale of land or any interest therein except for leases of a term no longer than 1 year. So a lease for longer than 1 year has to be in writing. If it's under 1 year, it does not have to be in writing. The exception to this, if somebody has paid part of the purchase price and taken possession of the land, then they say it does not have to be in writing, that they will go with a verbal contract or an agreement. And any contract for the sale of goods for a price of $500 or more has to be in writing, otherwise it's not enforceable. I had a situation where a fellow was trying to buy a home in Twickenham district, and the seller was out of town, and we didn't have an agreement. All of a sudden it was all falling apart, but what he did have was a number of telegrams from the seller in wherever he was located. And that is proper. If you can take that, the court will go as far as it can to take any writing and make a contract out where the people don't get hurt, and that you will provide and live up to the agreement. In that case, they took the different telegrams and put them together to have enough information, and really sketchy, but enough that they felt it was a valid contract, and the man got the home. All right. When you have a contract case and your client is talking to you, then you've got to decide whether or not he's been damaged, he's upset about something, somebody hadn't lived up to the contract, and he wants to know if there's anything you can do about it. To look at the breach of contract, you would look at the elements for the breach. And those are, number one, the existence of a contract between the plaintiff and the defendant. We went through whether or not there was that existence would exist, or that contract would exist. Did the plaintiff perform his part of the agreement? Did the defendant fail to perform, and was the plaintiff damaged by the defendant's failure? Now, in any lawsuit, this one or any tort action, you've got to have liability, some reason the defendant should be liable, contract or otherwise, and the plaintiff has to have been injured. If the defendant is liable and the plaintiff was not injured, there's no lawsuit. Even though he breached the agreement, if the plaintiff can't show injury, there's no lawsuit. And then on the third part of that is that the defendant, in order for any lawyer to take a case, the defendant's got to have the ability to pay whatever damages were to come out. And Alan and I both got multi-millions of dollars worth of verdicts that aren't worth anything because the defendant can't pay. Now, we obviously didn't know that when we started, or we wouldn't have started it. But if they can't pay, then that just takes care of the lawsuit, and you tell your client what the situation is and tell them it's a valuable lesson and hope it's not too valuable, and they have to go and find some other way to handle it. On damages, the defendant or the plaintiff has to mitigate his damages. If once the defendant breaches the agreement, if the plaintiff has the ability to reduce the damages, he's got to do it. He can't let somebody keep digging up his property or whatever just to increase the damages. He's got to mitigate it. Now, the damages for a breach of contract, number one, is compensatory damages. Compensatory damages in a contract case is that amount of money that would be required to put the plaintiff in the same position he'd have been in if the defendant had lived up and performed the contract. Now, sometimes that's not the contract price. If you've got a contract to perform services to haul gravel, and you're going to have to hire some additional people and rent some additional machinery, and because the defendant breached the agreement, you don't have to do that. You've cut those expenses out. So what you're looking there is profit. How much money would you have gotten? if you'd have made $200 out of a $1 million contract, $200 is going to be the damages. Of course, you shouldn't have been in that one to start with. That's calling it too close. Profits. That gets real difficult sometimes, talking about profits. I would have made profits. If the defendant had lived up to the agreement, I would have made profits. How much profit? And that gets real difficult because we're starting to speculate a little bit. But if damages are speculative, we just get minimal nominal damages, which I think in Tony Mason's case against Jack Daniel was $200. I don't know whether y'all remember that case, but he alleged that Jack Daniels had taken his recipe for Lynchburg lemonade. And the first time they tried it, the judge found that the damages were too speculative, how much Jack Daniels would have made. He ordered the jury to return nominal damages, and they finally came back with $200. I think they started at a few thousand, and he kept sending them back till they got nominal damages. So the damages sometimes aren't real easy to calculate in a contract case. There are, as a rule of law, punitive damages, and that's damages to punish the other side. You cannot receive punitive damages in a contract case. But the contract stands and serves as a basis for a lot of tort actions, such as fraud, such as bad faith, such as outrage, some kind of outrageous conduct. Somebody enters into a contract and never intends to fulfill that contract. That's fraudulent. And punitive damages would be awarded based on the fraud, but that would be a tort. But the basis of that tort would be the contract. You are able to obtain damages for mental anguish and physical suffering under certain type contracts. And those are the contracts where you would normally expect someone to suffer emotionally because of its breach. I'd say this has just come about over the last 6 or 7, 8, 9 years, something like that. Up to that point, you could not do it. But they found when you start messing with somebody's home, you flood it, you don't do something you should have done, that wears on people. And the law gives a lot of respect to somebody's home. There have been cases where the power companies have come out and cut off the utilities, and they have awarded mental anguish under those circumstances. I think of one case where they cut it off in the middle of the winter and those type things, and the people didn't have anywhere to go, and they're bundled up in the house, and then found out, well, the bill really was paid, and we got a problem here. But that's a contract case, and in that case, mental anguish is awarded. Another one that I don't know about, I would think possibly in some certain employment cases, if people lose their jobs for breach of a contract, that certainly would bring mental anguish if you're not well-to-do and retired and so forth and had income otherwise. I had a case one time, and thank goodness, I never really got to find out, but I had a client that took his car to be repaired, which was a contract, and the dealer agreed to repair the car, and rather than replacing the frame rails, they welded them. And now the only thing my client has got is this car. He doesn't have a house. He doesn't have a wife. He doesn't have any kids, and it was a nice car, and he loves this car. Well, he's coming down the road, and the frame rail breaks, and the car goes off to the right, runs into a bridge, tears his car all to pieces, and luckily did not hurt him. But we sued the repair shop for the breach of the contract and for fraud and so forth and so on. And we were in the middle of the trial when we settled it, but I was going to ask for mental anguish in that case, and I probably was just caused myself a lot of problems, to be honest with you, but we never got to that point. Alan will probably try that next time he tries one. Now, there are certain contracts that can be specifically enforced. And what we mean by that is we can make the other side live up to it. And the time we can do that is when the consideration is unique. A normal contract, real estate is unique. So all real estate contracts can be specifically enforced. Now, that'd be on the equity side, where you would ask the court to order the seller to sign the deed and convey me the house. Now, I wasn't going to tell you a case I lost, but I did lose a case trying to defend a lady. She didn't want to sell her house. And she came up with every excuse she'd come up with, and I really thought they'd give up and go away, and they didn't. And the court ordered her to sign the deed. So on a real estate contract, because real estate is always unique, under the law, no two pieces of real estate are the same. That will be specifically enforced. I'm sure if you had a diamond, you had something that was really unique, they would specifically enforce that agreement also. Now, there are certain agreements that I've talked generally about agreements now, but there are certain agreements that are kind of hot right now. One is agreements not to compete, and some of you have probably seen these. Employers, because of especially the nature of Huntsville, with a high-tech industry, they're concerned about employees taking their secrets somewhere else. And so they will enter into an agreement with the employee, providing that the employee cannot compete against them for a certain period of time. Now, those agreements, they are valid, but the court frowns on them because it keeps a person from earning a livelihood, and they really should frown on them. If the agreement is found to be reasonable within time, it's not for 10 years. Normally, a year or two, probably a year is fine. Maybe go 2 years. It's reasonable in time. It's reasonable in area. The employer only did business in Madison County, so this fellow shouldn't be prevented from competing in Nashville or California or some other area. So if it's reasonable in area and it's reasonable in time, and there was truly something to protect, they will enforce them. But they've watered them down. The court has watered. Each time they hear one, they normally enforce them. The ones I've seen, they've enforced. And I've handled one in a travel business where my client hired a lady and entered into an agreement with her to work there so long and provide that this lady would not go out and compete with her within Madison County for 6 months or a year, something like that. And I really think the only reason I won that case is this lady went out and opened up a shop in the same shopping center, except at the front on the parkway instead of at the back. And if she hadn't done that, the court probably would not have enforced that one. If she'd have gone a mile or two down the road, she probably would. The judge probably would not have enforced it. But in that case, they enforced this. What they did, the court entered an injunction and prohibited her from competing for 6 months, and that gave these people time to get on their feet. Prenuptial agreements are another area that of the law and contracts that has come to the forefront. Most of this stuff comes from California. It gets here a few years later, you know. I hope a lot of this stuff we've been seeing doesn't ever get here, but the prenuptial agreements, they certainly started out there, and now they're just normal course, normal business out there. And a prenuptial agreement is also a valid agreement if it's done right. And by that, generally what you've got to do is make sure that both parties disclose their assets to each other. Of course, the purpose of this is to provide that if there is death or if there is divorce, we know we'll end up with this property or our kids. And you see this more in people who are marrying for some time other than the first time they have children by prior marriages. But making sure how things are going to go upon their death, upon a divorce. Like I said, they're generally enforceable. You've got to be careful with them. You've got to make sure that you disclose all your assets and you give a value where either one won't come back and say, well, I didn't know he was worth $2 million. I thought he was worth $100,000. He didn't tell me that. I never would have entered into this. And that thing's probably going to be set aside if that's the case. In fact, I'm sure it would be. I litigated a prenuptial agreement. A lady and her husband were involved in a divorce, and they'd only been married 6 months. And they had a prenuptial agreement which the husband had drawn up. And this happens a lot. And he advised his lovely bride on the day of the wedding she'd need to go by the lawyer's office. That sounds crazy, but I hear that a lot. Have to wait to hold the preacher up while they sign the prenuptial agreement. Well, they go sign it, and she signs it, and it provides that upon their divorce, she will get $2,000 a month for 12 months. Well, at the end of 6 months, he felt like she had other male visitors in her life, and he wanted a divorce. So she came to see me, and she said, he won't pay me the $24,000. And I looked at the thing, and there's nowhere in there it says if she's committed adultery that she doesn't get the $24,000. Nowhere in there does it say they got to be married longer than 6 months. Now, the judge agreed with y'all. He didn't like what I was doing, but we went over there and said, well, you know, I talked to the other lawyer, and I said, look, you know, it's a valid agreement, but if you want it not to be an agreement, your man's worth a lot of money, we'll just tear it up, and we'll just do it all in here. And he said, no, we want to settle. We'll pay the $24,000. We go up to the judge, and the judge, he says, let me see that agreement. I laid it up there, and he said, how long were they married? I said, 6 months. He said, I'm not doing this. No, sir, I'm not. We're going to try this case. So we tried this case for 3 days. This is the honest truth. Tried this case for 3 days, and the judge had his clerk looking at the law every day. They were trying to prove adultery, and they really never did, but it was a little suspicious. But he finally decided he didn't have any choice. There was nothing in that contract that said they had to be married longer than 6 months, and there was nothing in that contract about cause. If we get a divorce for reasons other than adultery or whatever. So I learned a lot of law, and I think the judge learned a lot of law at that time. One thing I didn't tell you, and I need to tell you this is important. On the agreements not to compete, and I'm telling you, I'm starting to think very few lawyers know this. You cannot restrict a professional from competing. Now, that hadn't been interpreted all the way out. It's a learned profession. But the court has decided that a lawyer is a professional. He cannot be restricted from competing. A doctor is a professional. There's a case, an accountant is a professional. And it seems like and a dentist is a professional under the law. And it could be that an engineer and some others could be professionals if it was ever tried, and have the court interpret that. But there is a statute that says a professional cannot be restricted from their profession. And I got a letter the other day. I was representing a doctor, and these doctors had divided up their business. My doctor was an employee of the other doctor, and they divided up, and there was a no-compete. And the lawyer that wrote me is a lawyer that represents doctors all the time. He doesn't try cases. He's a business lawyer. And he said, we're going to associate counsel, and we're going to enjoin your client from practicing medicine in Madison County, Alabama. And I wrote back and I said, as I'm sure you are aware, section so-and-so of the Alabama Code provides that doctors are professionals and consequently cannot be restricted from their profession. Never heard from him again. I assume he knew that law and he was just fooling with me, but he might not have. I find that kind of interesting. This does not seem to be well known. All right, Mr. Brinkley, I think that's all I've got. We've got a little time for questions and answers if you can ask them and I can answer them.
Under this item D, other actions arising from contracts, and under 7 is outrage. What constitutes outrage?
Well, to tell you the truth, that is conduct that is shocking. What is the definition, Alan? Conduct that is shocking to the sensitivity and of a reasonable person, something along that line.
Of civilized people.
Of civilized people. I have never known, or Alan might, but I don't know of any outrage case that ever resulted in a verdict being rendered in this county. Do you?
No, it never came up when they propped the man's corpse up against the door and rang the doorbell.
Yeah, no, that's outrage.
The case that started the outrage, outrageous conduct was when a bunch of little boys came up, they found a dead man on the sidewalk. They knew where he lived, so they took him home and propped his corpse, it was frozen outside, up against the door and rang the doorbell. And of course his wife came to the door. And it gave her a real scare. The more exact word for outrage is the intentional infliction of emotional distress. And the definition of it that we say is that it is conduct that shocks the conscience and is so opprobrious that a civilized person wouldn't do it.
No, but it's related to contracts. What can you do in a contract that would constitute outrage?
There was,
Mortician doing that, wasn't there one where a mortician took the body back and put it on the doorstep or somewhere of the people because they didn't pay for the funeral?
I think that's right. I think
That would be where
I
I'd
think
see a
that's right.
contract.
I think outrage originally came up in some contract action, in a contract action, along with bad faith. It came to life about the same time, where some person who was in desperate need of financial assistance was mistreated, and I don't remember the facts of it.
Judge Younger says it has not come to Huntsville.
No, and I've tried a couple times, and it has not.
I want a scenario, just give me a quickie, it's too late to do anything about it, but we went out of the country. 30 years we paid our utility bill. We were out of the country for 6 weeks. We get a utility bill, we didn't pay it. The utility bill was less than the deposit that they had, yet they cut our electricity off, everything in our freezer, everything in our refrigerators spoiled. It was the middle of the summer. Nobody, sure if they call the house and tried to find us, we weren't there. But we were home within 6 weeks of the time we left. At the time we didn't know. Could I go back and get some mental anguish and physical? That infuriated me more than
Well, I tell you, it sounds outrageous. Does sound outrageous. They've got your money, and they've got enough to pay the bill, and
Been 2 years.
It was $10, $15 less. What?
Has it been 2 years?
It's been longer than 2 years.
statute of limitations probably got you. But I'm convinced that you could have collected for the damage that occurred. And it would have been property damage, whatever it was, and I doubt that you could have gotten emotional distress for that, but I certainly can understand why you'd be upset by it.
The hurt and caps on punitive damages and things, we are hearing in the news now about a man named Willie King in Florida who was under contract with a doctor to amputate a diabetic leg, and they amputated the wrong one, and they're saying that there's a cap on the damages that he can, is this contract, is that the way they would?
No, they would be suing under tort. There would be a contract for his contract with the hospital to be properly treated and so forth, and that would be a breach of that contract, but I don't see any reason they wouldn't file tort action in that. The cap in Alabama has been declared to be unconstitutional. I assume if you heard that in Florida, they do have a cap in Florida on punitive damages?
I don't know.
I don't know either.
That was what was, as I
But then,
recall.
if there was, there would be a cap on the punitive damages. If it's constitutional and so forth, whatever amount, $250,000, whatever it is. Now, I would assume he could still seek compensatory damages, and that would be to compensate him for what has happened to him, and hopefully they could get that amount up to an amount of money that he could use to take care of him. And that same hospital, I heard later, they've done something to somebody else. Unbelievable.
Could he get him for outrage?
That sounds pretty outrageous to me. I tell you, the situation on some of these causes of actions, that cause of action is so clear. No problem with statute of limitations. It is so clear that they have violated the standard of care and so forth. You don't have to look to these other causes of action. A lot of these causes of action came about because we had problems in other areas. Sometimes the defendant can't pay. The drunk that runs over you, a lot of times the drunk can't pay. He doesn't have any insurance. He doesn't have any money. That's how we started going to the bars. If the drunk had paid, nobody'd be looking to the bars. So I think, in that situation, you wouldn't have to look for another one. And I wouldn't fool with outrage. No, I sure wouldn't.
George, what they're getting confused about is they think they can't get punitive damages unless they use the outrage theory. The fact is there are other tort theories available, and
You get it on wantonness, you can get punitive damages. Negligence and then wantonness is a higher level of negligence. You can get punitive damages there.
But there was liability and there was injury.
Oh, absolutely.
And there was, therefore,
Well, see, he does have a breach of contract with that hospital. He has an implied contract to be treated properly. So there is a breach of contract. And sometimes the lawyers will use a breach of contract to get to the hospital because they have problems in the other areas. But in this one,
You got a question back there.
I've got a question.
sorry?
If you have a breach of contract case, you're plaintiff, if you win, and your contract does provide for payment of lawyer services, does the judge have does he have the authority? I guess he has authority, but is it common practice for him to limit the fees that the attorney can,
Yeah.
down 20% of normal usual?
Well, it's not normally limited that much, but it is kind of normal for the judge not to award all the attorney's fees.
But is there any recourse that a plaintiff can take against that? 20% sounds awfully low to me.
Well, it depends on the situation. Depends on the amount, depends on how much effort went into it, but a case that's tried, an average case, that I think that's too low. But the judge has the discretion to award a reasonable attorney's fee. And my experience is that they normally will not award all of the attorney's fees.
Well, does the attorney collect the difference from the plaintiff?
Depends on the situation. If it's a contingent fee case, the plaintiff would end up paying it.
That's a per hour fee.
Yeah, if that's what the agreement is. Most times the lawyer's going to take the case with the client, and you work out a fee, and then whatever is awarded will be applied to that fee, and if there's anything left over, the client's got to pay it. Yes, sir.
Just a question about what happens when a judgment is entered against another individual and they refuse to pay, basically.
Okay.
What steps are then available to the individual?
You can attach his property and garnish his wages, but you've got to identify him. You got to tell the sheriff which cars to go get. You got to identify the bank accounts. You got to tell them where the real estate is. I think the small claims court here, as I understand, they do a pretty good job of that. But there's a lot of times getting a judgment sometimes is just part of the battle. Collecting it's another part. They change, move off to another state, it makes it a lot more difficult to go across that state line. So sometimes it's pretty tough, and sometimes you don't collect them. But I was serious. He and I both have got millions of dollars worth of verdicts. Now, we don't take those cases if we don't think it's collectible. But sometimes we end up with them, and they're not collectible. Yes, sir. Anybody. Just write seal beside your name. I can't really explain that. Well, there's Dr. Larry. No, just write seal. Yes, sir. Mr. Larry, Dr. Larry.
What if you have in the contract, not just for attorney's fees, but you pay a $500 fee if there's litigation you lose?
Liquidated damages. Yeah, is that what you're talking about?
In addition to other damages, that's
Oh.
say attorney's fees or some sort of
You can do that. Yes, sir.
Some states have a right to rescind within a period of time. Now, is the contract out signed, there's no rescission?
Yeah, there are certain contracts you can rescind within 3 days. Consumer type loans, if they solicit you at your home, second mortgages, if you put a second mortgage on the house, you sign the papers and come back 3 days later and get the money. But there are certain contracts that are rescindable within 3 days.
Is that written in the contract, or is that just?
No, that's the law.
It's probably not going to be written in the contract.
Well, it probably is. I think the law requires it to be, and I know you do get a form. They do advise you. I think the law requires you to be advised of that. Yeah.
One more question.
Yes, sir.
You refer a couple of times to the indigent defendant, if you will. In, I guess in courts, there's a concept of deep pockets. Is there anything analogous to that within contract law?
Well, I'll tell you the truth. My experience is that we have had less trouble collecting on contract cases than we have on tort cases, because the people normally entering into contract have some business purpose, have some means, that type thing, where the tort case could be just the drunk coming out of the jail here one night and run over you. So you didn't choose to do business with him. Most of the tort cases, well, I guess that's a bad way to put it. But most of the contract cases, you're able to collect.
George, thank you so much.
Thank you.
To the extent that this educational program could be construed as an advertisement for any member of the faculty, the following statement is required by the bar. There is no representation made that the quality of legal services to be performed is greater than that of the services performed by any other lawyer.